Ah! 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 Yo, Slay Queen, we are here. We are back. We are hating California yet again. But hey, welcome, people. We don't have a California case for you right now. You understand now? My family friend, welcome to the family. We have a West Virginia case, a very nice family discount we give you now. All right. We have Paul versus National Life. I even have a little something for you. You ASMR fucking weirdos out there. Ready? Ready? Wasn't that great? 1 second. Oh, there you go. YouTube is so fucked up. It says, now there's one person. It says there was 0 person. I'm like, my mod is chatting to me. How are there 0 people? There is 1 people. 1 people. All right. So we have Paul versus National Life, a 1986 case, the year of my birth, from West Virginia. Neely wrote the opinion. I know it just didn't say you were there. I don't. No, pudding popping. All right. In September of 1977, Eliza Vickers, you know her? You know Aloha Jane Paul. Her name is Aloha Jane Paul. Both West Virginia residents took a weekend trip to Indiana. Why? We don't know. The 2 women were involved in a one-car... Wait. The 2 women were involved in a one-car collision on Interstate 65 in Indiana. Oh, okay. It clarifies. When Miss Vickers lost control of the car, the collision took both of them. So, bitch drove the car off the road. So it was not a collision with another car. Bitch drove the car into a mountain or a hill or a tree. Yes, chat. Yep. So the collision took both of their lives. Well, sounds like a West Virginia thing. The administrator of Miss Aloha Jane Paul's estate. Aloha, Jane. Aloha. Say hi to St. Peter. Aloha. Oh, God. Miss Paul's estate brought a wrongful death action. Okay, so both these bitches died. And now the people who are in charge of their estates, probably the kids, are suing the other people. Sound like West Virginia. Oh, guess what? They brought the suit against the National Life Accident Company in the Circuit Court of Kanawha County. Upon completion of discovery, the defendants below moved for summary judgment. Defendants' motion contended that 1, the Indiana guest statute, which grants to a gratuitous host immunity from liability for injury of death. Okay, so basically, like, California's like, if you fuck up a California resident on our fucking highways, we're gonna fucking sue you and take your children and your dog and everything else. Indiana's like, nope, we're not doing that. If your dumbass is here and you murder somebody, fuck off. Go back home. We don't care. So Indiana is doing opposite of California. So the Indiana gas statute is granted a gratuitous host immunity from liability for injury or death of a passenger unless the host was guilty of willful and wanton misconduct, which means like driving down the road, Miss Aloha, Jane Paul driving down the road, motorcyclist driving down the other side of the road. I hate motorcyclists. Driver of the road, kill him. Then she would be liable. Okay. That's what it's saying. And 2, that the record was devoid of any evidence of any willful or wanton misconduct on the part of Miss Vickers. Seems like it. The sole question presented in this case is whether the law of Indiana or the law of West Virginia should apply. The appellees urge us to adhere to our traditional conflicts doctrine of the lex loci doctrine, meaning the law of the place where it occurred. Oh, lex loci delecti, the law of the place where the wrong occurred. Delecti means wrong, lex is law, loci means the place. So law of where the wrong occurred. Lex loci delecti, the place of the wrong. You get a free Latin lesson too. Yay, us. The appellants urge us to reject our traditional doctrine and adopt one of the modern approaches to conflict questions. Although we stand by the lex loci delecti as our general conflict rule, we nevertheless reverse judgment to the court below. Well, let's see how the fuck this happened. Unlike other areas of the law, such as contracts and torts, property, conflicts of law, as the body of common law is a relatively recent origin, meaning we're making shit up as we go. Professor Dicey, you're citing somebody whose name is Professor Dicey. Well, good luck with that. Has written that he knew of no occasion in England, West Virginia, and Indiana are not in England. Sounds super fucking dicey to me. Let's see where he goes. Considering conflicts of law before the accession of James I. So he's talking about law that existed in England before the accession of James I, King of England. We're talking Crusades. No, after the Crusades. Wait, yeah. No, Crusades. And it's generally acknowledged that this first authoritative work on conflicts did not appear until Joseph Story's conflicts in 1834. 50 years before the Civil War. This is a bit ago. If you don't remember the Civil War, it's probably good because you weren't fucking alive then. Accordingly, no conflicts of law doctrine has ever held an incredible pretense among natural law. Emerging from the murky merits of medieval mysticism. Oh, medieval mysticism. Fun. Sounds like West Virginia. Mysticism. This fog of mysticism. Indeed, the mention of conflict of law and the jus naturel, and we're speaking French now, in the same breath would evoke a power guffaw in even the sternest scholar. In our post-realist legal world, post-legalist, it means it's bullshit. I got you. There's received wisdom that judges, like their counterparts in the legislative branch, are political agents embodying social behavior. Damn right they are. Nowhere is this received wisdom more accurate than in domain of conflict of laws. So they're talking shit kind of on how California does shit, but watch, they'll get the wrong answer, I bet you. Conflict of law has become a veritable playpen for judicial policymakers in the last 20 years. And they've seen a remarkable, I like this judge's fucking snark. I like it. And has seen a remarkable shift from the doctrine of lex loci delecti to more modern doctrines, such as the more flexible, manipulatable restatement of the center of gravity test. Of the 25 landmark cases cited by appellants in which a state Supreme Court rejects lex loci delecti and has adopted a modern approach, the great majority of them involved an application to an automobile accident caused of a foreign state's gas statute doctrine and an interspousal or interfamilial immunity and the doctrine of contributory negligence. All but one of the landmark cases were decided in decades between 63 and 73. and many jurisdictions still retain guest statutes, the doctrine of interspousal immunity, and the doctrine of contributory negligence. However, in the years since 1970, these statutes and doctrines have all but disappeared from American legal landscape, except in California, where they'll do whatever they can to fuck you over how they can. That wasn't he. I said that. He didn't say that. Thus, nearly half of the state Supreme Courts of the country have wrought a radical transformation of their procedural law of conflicts in order to sidestep perceived substantive evils, only to discover later that those evils had been exercised from American law by other means. Meaning, California, you don't have to be a fuck. We can do this in other ways. Now, these courts are saddled with a cumbersome and unwieldy body of conflict. I love this opinion. Yay, West Virginia. And conflicts law that creates confusion, uncertainty, and inconsistency, as well as a complication of the judicial task. The approach has been like that of the misguided physician who treated the cause of dandruff with nitric acid. I love this fucking guy. Only to discover later the malady could have remedied with medicated shampoo. Okay, so let me just break that down. So you go to a hospital. Your motherfucker's got dandruff, right? Dandruff. And the physician's like, hey, nitric acid. That'll burn your scalp off. So he's like, nitric acid. So no hair, no skin, just open fucking wounds. Nitric acid. So California was treating dandruff with nitric acid. They were burning all the shit away for no reason. And later he's like, oh, you know what? Some Head and Shoulders. That would have worked probably better. Yeah, probably Head and Shoulders would have been better. Yep. That's what this judge is saying. I love this judge. He'll be my spirit animal. And then, oh, this is so funny. He says then, neither the doctor nor the patient had actually needed to lose their head. Get it? He is Neely, Jay Neely, Justice Neely. 1986, that was when I was born. He might be alive. He might be. I hope he was young. He might be alive. Neely, Neely. Neely. Probably dead. Fuck. The restatement approach has been criticized for its indeterminate language and a lack of concrete guideposts. The court here quotes section 145 of the second restatement of conflicts, pages 227 through 228. Yeah. Second Circuit Canal. Yep. Oh, no. This is West Virginia Supreme Court. The original case was in Kanawha. This is West Virginia Supreme Court. I think it's also in Kanawha, because that's where the capital is. So I think the Supreme Court of West Virginia is also in Kanawha. But it's not the Second Circuit. It's the Supreme Court. So quoting, personal injuries. In an action for personal injury, the local law of the state where the injury occurred determines the rights and liabilities of all parties, unless with respect to particular issues some other state has a more significant relationship under the principles stated in Section 6 to the occurrence and the parties in which event the local law of the other state will then be applied. Jay Neely, yeah. Is he alive? Is he still sitting? Is he still on the court? Chat! Yes, John Neely. God damn it, Neely! He's got to be old as shit, though. Like, if he was still on the court, I would be sending him an email tomorrow and be like, bro, let me clerk for you. I don't give a shit. I got in the law game a year too late. Damn you, Neely. I like this fucking guy, though. I like him. I like him a lot. We can maybe go have coffee with him sometime. Just go stalk him for a while and then figure out where he lives. Be like, hey, motherfucker, you want some coffee? It's not going to go well. Is he still alive? There's no obituary. There's probably Wikipedia, but he's not dead yet, right? Right? He's not dialed, is he? We can make him some fucking pumpkin bread. It'll be great. He'll be like, back in my day when I wrote. I like his opinion. It's good. Yeah, who knows, man? Him and Taylor Swift. Section 6 of the restatements. I'm going to fucking... I hope they call me tomorrow. I'm going to stick up for you. Like, Neely's fucking right. California's fucking wrong. Fuck the police. Section 6 of restatement lists the following factors are imposed by choice of law considerations in all areas of law. All areas of law. We emphasize that we adopted... What we adopted was not a rule. Oh, great. But a method of analysis that permitted the dissection of the juror bundle constituting a tort and its environment to determine what elements therein were relevant to reasonable choice of law. Okay. This sounds pretty intellectual. This is great. I still love this guy. He says, this sounds pretty intellectual, comma, but we would still actually prefer a rule. The lesson of history is that methods of analysis that permit dissection of a juror bundle constituting a tort and its environment produce protracted litigation and voluminous, inscrutable appellate opinions, while rules get cases settled quickly and cheaply. I love this fucking guy. The manipulability inherent in this restatement approach is nicely illustrated by two cases from New York, from the first jurisdiction to make a clean break with lex loci delicti. The cases of Babcock and Jansen and Kell versus Henderson are aptly discussed by the Supreme Court of Virginia. Quote, William Babcock, an automobile guest, sued for her host in a New York residence for injuries sustained by an Ontario resident. Sustained in Ontario, I beg your pardon, caused by the defendant's originary negligence. Under New York law, the guest could recover only for injuries caused by the host's lack of ordinary care. But under Ontario law, because that's Canada, don't you see, boy? The guest statute bars such a recovery, boy. The court abandons adherence to the place of the wrong rule. That's what lex loci delicti means. Place of the wrong rule, you understand now? And permitted recovery. It decided that the guest host issue, New York, had a dominant contacts, because the parties were domiciled in New York, you understand, boy? Were on a trip which began in New York. See, they were on a trip to Ontario, but it began in New York. And they were traveling in a vehicle that was registered and regulated and tagged in New York. The court noted that Ontario had no connection with the cause of the action except that the action happened to take place in Ontario. Sounds retarded, right? Because it is. Kell, different case, presented the converse of Babcock, the opposite of Babcock, if you will. There, the question was also whether New York's ordinary negligence rule applied or whether the Ontario guest statute applied. The guest was injured by the host's ordinary negligence. While both parties were residents of Ontario, they were on a trip to New York, which was to begin and to end in Ontario. The New York court purported to follow Babcock, but held the Ontario law. Now fucking New York's doing this California shit. Would not apply. McMillan versus McMillan was perhaps the recognition of how fucked up this was. They said gross disparities, but I'm trying to translate to how fucked up this was. And the result prompted the Court of Appeals in New York to remark in a towering achievement in the art of understanding. Oh, this is great. I fucking love this guy. It prompted the Court of Appeals of New York to remark in a towering achievement in the art of the understatement. Candor requires the admission that our past decisions lacked a price consistency. This is hot. I'm here for it. He better call me or I'm going to be like, fucking call me, bitch. The appellant urges us in the alternative to adopt the choice influencing considerations approach set forth by Professor Layfar in Choice Influencing Consideration Conflict of Law, New York Review of Law, 1966. Professor Layfar has narrowed the list of considerations in conflict cases to 5. The court lists them. We're not going to cover them. And then our boy here in West Virginia says, Professor Layfar's approach has been adopted in the guest statute context in landmark cases of Clark v. Clark, Milokovic v. Sarari, and Konkin v. Honer. In practice, the cases tend to focus more on the 4th and 5th considerations than on the first 3. And the upshot is the courts of New Hampshire, Minnesota, and Wisconsin simply will not apply any of these statutes. So he's saying that basically this professor is so fucked up that we have 3 states who are in our district that give him the finger and say, we're not even dealing with you, dude. Cool. However, it seems unnecessary to scrap an entire body of law and dress the rule up in a newfangled 5-factor costume when the same concerns can be addressed and the same results achieved through judicial employment of the traditional public policy exception of lex loci electi. I fucking love this guy. Oh, I'm here for it. We need to take him to lunch, babe. We really need to. If he's still fucking alive, I want to buy this fucking guy a beer. Like, for real. You need to do some fucking sleuthy, pooky research. Give me an email address. Tomorrow. Like, tomorrow. And take him out to a nice seafood dinner at not Tricky Fish, the other one. What's it called? The fish place by the Outback. The nice one. That one. Under the sea. Whatever the fuck it's called. 3. Lex loci delecti has long been the cornerstone of our conflict of laws doctrine. Yeah, Soho. Yeah, those hoes. Yeah, those hoes, the Sohos, the ho-hos, the go-go's. And the ease of application, he better call me tomorrow or I'm going to be like, bitch! West Virginia law. Uber alles. The appellant contends that various exceptions have been engrafted into the traditional rule and have made it manipulable and have undermined the predictability and, yeah, I bet, thank you, California, and uniformity that were considered its primary virtues. There is certainly some truth in this, as we have generally eschewed the more strained escape devices. We eschew the more strained escape devices employed to avoid sometimes harsh effects of the traditional rule. Nevertheless, we remain convinced that the traditional rule, for all of its faults, remains superior to any modern contemporaries. Moreover, if we are going to manipulate the conflicts doctrine in order to achieve substantive results, we might as well manipulate something we understand. Oh my God! If we are going to manipulate the conflicts doctrine in order to achieve substantive results, meaning results we want to have, right? We might as well manipulate something we actually understand. I love this guy. Having mastered marble. Having mastered marble, we decline an apprenticeship in bronze. We therefore reaffirm our adherence to the doctrine of lex loci delecta today. However, we have long recognized the comedy that corresponds between states does not require the application of substantive law to a foreign state when that law contravenes the public policy of the state. West Virginia has never had an automobile guest passenger statute. It is a strong public policy of this state of West Virginia that persons injured by the negligence of another state should be able to recover in tort. Accordingly, we've abolished the doctrine of interspousal immunity. Basically, if you're driving the fucking car and you're an idiot and you fucking wreck it and your wife dies, you still pay. You can still get money from the insurance company to pay for your wife's thing, right? All right. And have adopted the doctrine of comparative negligence in preference to the harsh rule of contributory negligence. We abolished the charitable immunity for hospitals in Atkins versus St. Proud's Hospital. We held that there is no common law governmental immunity for municipal corporations in Higginbotham versus City of Charleston, and have abrogated the doctrine of parental immunity to permit an unemancipated minor child to sue for injuries received in a motor vehicle accident in Lee versus Comer. Today, we declare that automobile guest passenger statutes violate the strong public policy of this state in favor of compensating persons injured by the negligence of others. Accordingly, we will no longer enforce the automobile guest passenger statutes of any foreign jurisdictions in our courts. Fuck you, California. Fuck you, New York. We're taking it back. For the foregoing reasons, the order of the circuit granting summary judgment in favor of the appellees is hereby vacated, and the cause is remanded for further considerations in congruence with the proceedings, and not those inconsistent with this opinion. I love that last bit. He is a boss. He is a boss bitch, and I love him. I want to take him home and kiss him on the forehead. All right, kids. I hope I get called in tomorrow. That's a fucking great one. No, we have one more too, but I'm not gonna do this one more because it's so long. We're not gonna do it. That was it. Hey, other viewer who's here. Hey, other viewer. Wait, is a law firm? Off chat, give me his number. We're gonna take him out for a nice seafood dinner at Soho's. I'm gonna be like, you see this? This is poetry to me. This is the most beautiful decision I've ever fucking listened to. It's lovely. So next weekend, we're going to do it. All right. Hey, other viewer I'm not sure when you got here, other viewer, but we're talking about West Virginia law, and I was going off because it makes way more sense than California law, which is a bunch of bullshit. So we watch. If you want to say hi in the chat, viewer, like and subscribe, do the things. Millionaires eat Subway too, Pookie. All right. But we're done for now. But go back and watch. This is Conflicts of Law, Wrinkles in the Theory, Statute of Limitations, and Interstate Law. California sucks. West Virginia, surprisingly, had a judge who's a badass. He's a fucking G. And his name is Judge Neely. John Neely. Who knew? I didn't know. Did you know? I didn't know. Now I know. We're going to do it. Do the things. Tip your waitresses. Tip your hostesses. Tip your hookers. Don't give them just a tip. Give them more than just a tip. And we'll see you next time, tomorrow afternoon, for a Rule of Law seminar reading from Hamburger's book, The Judicial System and Its Tyranny. Stand by and stay tuned. God bless and good night.